This again, the day's breaking news from Sanford, Florida, released to ABC News and now everywhere, of course. Video from some moments after the killing on February 26th of Trayvon Martin in that city of the man who fired the gun, allegedly in self-defense, George Zimmerman, who's not been arrested nor charged with any crime, being taken by police out of that police vehicle into the headquarters of Sanford police headquarters. No determined time yet as to how long after the event this took place. But the details of what you don't see as you get this good profile view and then a back view and briefly a front view of this man's head, summarized by an article in the Orlando Sentinel. Police say Zimmerman told them he shot Trayvon Martin in defense after the 6-foot high school junior punched him, got on top of him, then began banging his head into a sidewalk. Zimmerman was bleeding from his nose and the back of his head, according to a police report, but the video, as you see here, shows no obvious sign of injury. He was tended to at the scene by paramedics, but told them he did not need to go to a hospital, police reported. This extraordinary video. For an understanding of that and the other legal developments today, Jonathan Turley of George Washington University Law and a Countdown contributor has joined us again. Give me your initial impression, John, of the legal meaning and value of this videotape.
Well, you know, as a criminal defense attorney, I have to say this is pretty bad evidence for his defense. You know, it is potentially admissible. You know, the whole basis upon self-defense here is that he faced a reasonable fear of serious bodily injury or death. And he, at least through the police have claimed that he has said that he was beaten and jumped by Martin. That would make this tape potentially admissible, potentially relevant. The other problem with this tape, by the way, that I would have as a on the criminal defense side, is that, you know, we're very careful never to show a defendant or to allow a defendant to be shown in court wearing handcuffs or prison garb in front of a jury. If this is admissible, it's a type of thing that you never want a jury to see the client actually in cuffs surrounded by police officers. The jurors, like everyone else, are extremely visual. You know, the impact of seeing a video has a pronounced impact on their view of a crime or a crime scene. So it hurts on both the substantive defense. It also hurts potentially tactically for his defense counsel.
30 seconds on this point. The report from the special prosecutor there that the police in Sanford wanted to charge him with a crime went to the county representative of the state prosecutorial force, the state prosecutor in Seminole County, and said, we want to arrest him, and we're either overruled or the thing was just pigeonholed and left there. Is that standard procedure that the cops in this scenario would then go to the county prosecutor?
Well, it is not unheard of in some jurisdictions for even ADAs, assistant district attorneys, to ride along with police officers. I'm surprised he was not arrested. I've seen indictments based on less evidence than this. And so for that reason, I'm very surprised to see that the initial recommendation of a charge appears to be either overridden or simply not acted upon. I think that this tape is going to cause even greater anger towards that decision. You know, it is certainly the case that you can use lethal force against an unarmed individual in many states and be viewed as acting in self-defense. But it's difficult, and you usually have more of a showing from the beating than what we see here.
Jonathan Turley of George Washington University, criminal defense attorney, Countdown contributor. Thanks for staying with us on this.
Thanks, Keith.
Thank you. That's Countdown. I'm Keith Olbermann. Good night.